Hello students, welcome to the lecture on legal systems, and after this lecture we will be able to learn the following objectives. Understand legal systems, describe property rights, explain production safety and product liability, explain determinants of economic development, describe economic development, political economy and economic progress. Describe states in transition and nature of economic transformation, and understand the implications for business. Let us first discuss about the legal system. There are hundreds of legal systems in the world. At the global level, international law is of great importance, whether created by the practice of sovereign states or by agreement among them in the form of treaties and other accords. Some transnational entities, such as the European Union, have created their own legal structures. At the national level, there are over 180 sovereign states in the United Nations organization. Many of these are federal or non-federal, and their constituent parts may well have their own law. But despite this great variety, it is important to begin by emphasizing one great division, that into religious and secular legal systems. Each side of the split holds quite different views as to law in its source, scope, sanctions and function. The source of religious law is the deity legislating through the prophets. Secular law is made by human beings, and one of its most famous examples begin with the words, "We the people." It follows from this difference in their source that religious laws are perceived to be eternal and immutable, while secular rules can be changed by their makers. Let's discuss about property rights. One of the most fundamental requirements of a capitalist economic system and one of the most misunderstood concepts is a strong system of property rights. For decades, social critics in the United States and throughout the Western world have complained that property rights too often take precedence over human rights, with the result that people are treated unequally and have unequal opportunities. Inequality exists in any society, but the purported conflict between property rights and human rights is a mirage. Property rights are human rights. The definition, allocation and protection of property rights comprise one of the most complex and difficult sets of issues that any society has to resolve, but one that must be resolved in some fashion. For the most part, social critics of property rights do not want to abolish those rights. Rather, they want to transfer them from private ownership to government ownership. Some transfers to public ownership or control, which is similar, make an economy more effective. Others make it less effective. The worst outcome by far occurs when property rights really are abolished. A property right is the exclusive authority to determine how a resource is used, whether that resource is owned by government or by individuals. Society approves the uses selected by the holder of the property right with the governmental administered force and with social ostracism. If the resource is owned by the government, the agent who determines its use has to operate under a set of rules determined in the United States by Congress or by executive agencies it is charged with that role. Private property rights have two other attributes in addition to determining the use of a resource. One is the exclusive right to the services of the resource. Thus, for example, the owner of an apartment with complete property rights to the apartment has the right to determine whether to rent it out and, if so, which tenant to rent to live in it himself or to use it in any other peaceful way. That is the right to determine the use. If the owner rents out this apartment, he also has the right to all the rental income from the property. That is the right to the services of the resources, the rent. Finally, a private property right includes the right to delegate, rent, or sell any portion of the rights by exchange or gift at whatever price the owner determines, provided someone is willing to pay that price. The three basic elements of private property are exclusivity of rights to choose the use of a resource, exclusivity of rights to the services of a resource, rights to exchange the resource at mutually agreeable terms. The US Supreme Court has vacillated about this third aspect of property rights. But no matter what words the justices use to rationalize such decisions, the fact is that such limitations as price controls and restrictions on the right to sell at mutually agreeable terms are reductions of private property rights. Many economists believe that most such restrictions on property rights are detrimental to society. Here are some of the reasons why. Under a private property system, the market values of property reflect the preferences and demands of the rest of society. No matter who the owner is, the use of the resource is influenced by what the rest of the public thinks is the most valuable use. Let us move on to our other topic, that is product safety and product liability. It is very important for the entrepreneur to assess whether any product that is to be marketed in the new venture is subject to any regulations under the Consumer Product Safety Act. The Act, which was passed in 1972, created a 5-member commission that has the power to prescribe safety standards for more than 15,000 types of consumer products. In addition to setting standards for products, the Commission also has a great deal of responsibility and power to identify what it considers being substantial hazards and barring products it considers unsafe. It is especially active in recognizing whether possible product defects may be hazardous to consumers. When this is the case, the Commission will request the manufacturer in writing to take corrective action. The Act was amended and signed into law in 1990. The amended law establishes stricter guidelines for reporting product defects and any injury or death resulting from such defects. Manufacturers could be subjected to fines of $1.25 million for failing to report product liability settlements or court awards. Manufacturers have presented their concerns to the consumer. Product Safety Commission about information in these reports becoming public prematurely. This information could prove damaging even when the Commission may subsequently find that the firm was not negligent. Any new product that is responsible for the entrepreneur's entry into a business should be assessed to ascertain whether it falls under the Consumer Product Safety Act. If it does, the entrepreneur will have to follow the appropriate procedures to ensure that he or she has met all the necessary requirements. Product liability problems are complex and continue to be an important consideration for entrepreneurs. Changes in the legislation, thus for unsuccessful, were felt to be necessary to address many long-time concerns of businesses, such as the amount of punitive damages allowed in certain cases and the application of the product liability laws to durable goods that have been in use for more than 15 years. Changes in the global market have also contributed to the need for reform. Risk managers claim that without new reform legislation, startup companies that do not have a product liability track record may have difficulty finding this type of coverage. Let us understand the contract law. Contract law has for centuries promoted international trade, and complied with the necessities of international economic relations. As a result of tight integration of EU countries, breaking of obstacles for free movement of capital, goods, services and labour, new trends are appearing in contract law. Latvia, in accordance with the decision made by EU Council in Helsinki in December 1999, has already commenced discussion on entry into the EU. Significant work has already been accomplished for the harmonization of the law of Latvia with the law of the EU. However, the EU does not require complete unification of the law. The law of each country has differences, and such differences shall remain. Variety of contract types. Matters of concluding and execution of contracts, as well as general principles of liability, are subject to the civil law of the year 1937, reintroduced in parts in 1992 and 1993 respectively. Since the reintroduction, the fourth part of the CLA has neither been amended nor perfected. However, many other laws have been adopted which detail and develop specific types of contracts within the limits and basis of general principles of CLA. Several laws and regulations of the Cabinet of Ministers can be mentioned which, beside other transport-related issues covered by them, regulate carriage as well. They are Latvian Maritime Rules, Maritime Code, and Aviation Act, both adopted in 1994, Cargo Act, adopted in 1995, Road Traffic Act, adopted in 1997, and Railway Shipping Act, adopted in 2001. The reform of the court system and improvement of the court practice. As of the year 1992, a judicial reform for ensuring the execution of laws and the improvement of dispute litigation has been implemented in Latvia. Appeal and cassation proceedings have been introduced. The new Civil Procedure Act, adopted on 14th October 1998 and effective as of 1st March 1999, replaced the Civil Procedure Code 11, initially adopted in 1963 during the Soviet regime and amended frequently afterwards. Laws on judicial reform and civil proceedings have not ensured everything that is necessary for courts, premises, computers, and a sufficient number of judges. Therefore, courts are often reprimanded regarding slow work as well as about quality of verdicts. Specific features of Latvian contract law. Research into the differences of Latvian contract law in comparison to the law of other countries revealed a few noteworthy matters. Let us discuss about determinants of economic development. Economic factors play a very important role in the development of a country. Economic development is a complex process. It is influenced by a number of factors such as natural resources, capital, human resources, technology, social attitude of the people, and political condition in the country. All the factors having strong bearing on economic growth are divided into two categories: economic and non-economic. Capital accumulation or capital formation is an important factor in the economic growth of a country. Capital formation refers to the process of adding to the stock of capital over time. The stock of capital can be built up and increased through three different resources, which are as under. Sources of capital formation: an act of saving, capital market, an act of investment. Human resources of a country are an important factor in economic development. If the population of a country is educated, efficient, patriot, skilled, healthy, it makes significant contribution to economic development. On the other hand, If a country is overpopulated, labor force is unemployed, uneducated, unskilled and unpatriotic, it can put serious hurdles on the path of economic development.
Central Florida, home to one of the most vibrant and thriving economic success stories in the country. Much of that success has resulted from the efforts of the Metro Orlando Economic Development Commission and its many supporters and partners. Located in offices around Central Florida, the EDC seeks to attract new business investment to the area, create jobs from that investment, and help the companies here grow and thrive. That means actively marketing Central Florida to industries and companies far and wide, while simultaneously working within our community to retain and grow jobs with the businesses that are already here. The results create jobs that generate income to improve our quality of life, so people build things, pay taxes, raise families, and invest in a continuous cycle of economic growth. The Metro Orlando EDC depends greatly on support from companies like yours to fuel the important work we do. At home, that means helping local businesses grow and be more successful. Abroad, we travel worldwide to industry conferences and trade shows, promoting our region as a growth-oriented investment opportunity. Our services include market research, economic data, site selection, permitting, financing referrals, anything it takes to consolidate the region's resources and support the industries that make Metro Orlando home.
Power resources are the foundation of economic development. They are derived mainly from two types of sources, commercial and non-commercial. Commercial resources of power are oil, gas, coal, hide, thermal electricity and nuclear. Non-commercial sources include animal power, fuel, wood, cow dung. The means of transport and communication have an important bearing on the economic growth of a country. If a country is well connected with railroad, seaports, and has a developed means of communication, including information technology, it then helps in improving the productive capacity of the various sectors of the economy. An efficient transport and communication network contributes to improving the quantity and quality of goods due to competition and reduction in production costs. The means of transport and communication have an important bearing on the economic growth of a country. If a country is well connected with railroad, seaports, and has a well-developed means of communication, including information technology, it then helps in improving the productive capacity of the various sectors of the economy. Economic progress can be defined as a continuous gain in the relative efficiency of the coordination and utilization of goal-directed human labor, while technological progress can correlatively be defined as a continuous gain in the knowledge of how best to coordinate and utilize goal-directed human labor. This may seem like a rather strange definition of technological progress to some. The reason for this is because technology is popularly understood to be the physical products of our science, like computers and cars and iPods, etc. These products are not technology, however. They are merely the products of technology. Now we shall discuss about states in transition. The transition state is an intermediate state in which both attacking and leaving groups are partly bound to the molecule. The spread of democracy. Among the criteria that Freedom House uses to determine ratings for political freedom are the following: free and fair elections of the head of state and legislative representatives, fair electoral laws, equal campaigning opportunities, and fair polling, the right to organize into different political parties, a parliament with effective power, a significant opposition that has a realistic chance of gaining power, the spread of market-based systems. Paralleling the spread of democracy has been the transformation from centrally planned command economies to market-based economies. A complete list of countries would also include Asian states such as China and Vietnam, as well as African countries such as Angola. The underlying rationale for economic transformation has been the same the world over. In general, command and mixed economies failed to deliver the kind of sustained economic performance that was achieved by countries adopting market-based systems. Let us now discuss about nature of economic transformation. Nature of economic transformation is deregulation. Deregulation involves removing legal restrictions to the free play of markets, the establishment of private enterprises, and the manner in which private enterprises operate. In mixed economies, deregulation has involved abolishing laws that either prohibited private enterprises from competing in certain sectors of the economy or regulated the manner in which they operated. Privatization. Privatization transfers the ownership of state property into the hands of private individuals, frequently by the sale of state assets through an auction. Privatization is seen as a way to unlock gains in economic efficiency by giving new private owners a powerful incentive thereward of greater profits to search for increases in productivity, to enter new markets, and to exit losing ones. Implications. The global changes in political and economic systems discussed above have several implications for international business. The free market ideology of the West has won the Cold War and has never been more widespread than it was at the beginning of the millennium. Although command economies still remain and totalitarian dictatorships can still be found around the world, the tide is running in favor of free markets and democracy. Now we move on to our next topic, that is implications for business. With regard to economic factors, one of the most important variables is the sophistication of a country's economy. It may be more costly to do business in relatively primitive or undeveloped economies because of the lack of infrastructure and supporting businesses. Benefits. In the most general sense, the long-run monetary benefits of doing business in a country are a function of the size of the market, the present wealth. While international businesses need to be aware of this distinction, they also need to keep in mind the likely future prospects of a country. By identifying and investing early in a potential future economic star, international firms may build brand, loyalty, and gain experience in that country's business practices. These will pay back substantial dividends if that country achieves sustained high economic growth rates. In contrast, late entrants may find that they lack the brand loyalty and experience necessary to achieve a significant presence in the market. In the language of business strategy, early entrants into potential future economic stars may be able to reap substantial first mover advantages, while late entrants may fall victim to late mover disadvantages. Costs. A number of political, economic, and legal factors determine the costs of doing business in a country. With regard to political factors, the costs of doing business in a country can be increased by a need to pay off the politically powerful in order to be allowed by the government to do business. The need to pay what are essentially bribes is greater in closed totalitarian states than in open democratic societies where politicians are held accountable by the electorate. Whether a company should actually pay bribes in return for market access hold be determined on the basis of the legal and ethical implications of such action. Risks. As with costs, the risks of doing business in a country are determined by a number of political, economic, and legal factors. On the political front, there is the issue of political risk. Political risk has been defined as the likelihood that political forces will cause drastic changes in a country's business environment that adversely affect the profit and other goals of a particular business. Companies and banks might go bankrupt, pulled their money out of these countries, selling local stocks, bonds, and currency. On the legal front, risks arise when a country's legal system fails to provide adequate safeguards in the case of contract violations or to protect property rights. Overall attractiveness. The overall attractiveness of a country as a potential market and or investment site for an international business depends on balancing the benefits, costs, and risks associated with doing business in that country. Generally, the costs and risks associated with doing business in a foreign country are typically lower in economically advanced and politically stable democratic nations and greater in less developed and politically unstable nations. The calculus is complicated, however, by the fact that the potential long-run benefits bear little relationship to a nation's current stage of economic development or political stability. Rather, the benefits depend on likely future economic growth rates. Economic growth appears to be a function of a free market system and a country's capacity for growth. Ethics and human rights. One major ethical dilemma facing firms from democratic nations is whether they should do business in totalitarian countries that routinely violate the human rights of their citizens. There are two sides to this issue. Some argue that investing in totalitarian countries provides comfort to dictators and can help prop up repressive regimes that abuse basic human rights. Ethics and regulations. A second important ethical issue is whether an international firm should adhere to the same standards of product safety, work safety, and environmental protection that are required in its home country. This is of particular concern to many firms based in Western nations where product safety, worker safety, and environmental protection laws are among the toughest in the world. Again, there is no easy answer. While on the face of it, the argument for adhering to Western standards might seem strong, on closer examination, the issue becomes more complicated. Ethics and corruption. A final ethical issue concerns bribes and corruption. Should an international business pay bribes to corrupt government officials to gain market access to a foreign country? To most Westerners, bribery seems to be a corrupt and morally repugnant way of doing business, so the answer might initially be no. Some countries have laws on their books that prohibit their citizens from paying bribes to foreign government officials in return for economic favors. Now, in the end, let us summarize what we have learnt in this lecture. It is important to begin by emphasizing one great division that into religious and secular legal systems. A property right is the exclusive authority. It is very important for the entrepreneur to assess whether any product that is to be marketed in the new venture is subject to any regulations under the Consumer Product Safety Act. Contract law has for centuries promoted international trade and complied with the necessities of international economic relations. Economic development is a complex process. The transition state is an intermediate state in which both attacking and leaving groups are partly bound to the molecule. In such a world, much of the economic promise inherent in the global shift toward market-based economic systems. Business depends on balancing the benefits, costs, and risks associated with doing business in that country.